screen now?
Yes.
Okay, good afternoon everyone. My name is Stephanie Lambert and I'm a partner at HFW. I'm also a committee member of the Executive Committee of the Women Lawyers Association of New South Wales. HFW is very proud to be able to host this webinar on behalf of the association, particularly as it means that the association can continue to bring its members these events in circumstances where face-to-face is not possible. We're going to, our guest speaker is able to answer questions throughout the presentation. As a bit of housekeeping, these can be answered via the chat button, which is found at the bottom of your Zoom screen. If you post a question to the chat, she will be able to answer those at appropriate times throughout the presentation. But apologies in advance, just given the time if they can't all be answered. So I'll introduce now our guest speaker, which is Professor Tania Sourdin. She is the Dean of the University of Newcastle Law School. She was previously the Foundation Chair and Director of the Australian Centre for Justice Innovation at Monash University in Australia. She is a great advocate for diversity in law school and is also been involved in many research projects into aspects of dispute resolution and justice in many courts and tribunals and external dispute resolution systems within Australia. Other research projects of hers have focused on justice, innovation and technology, including the use of artificial intelligence in the legal domain. So in this presentation, she will be discussing technology in the practice of law and how it is impacting upon the profession and the delivery of justice. Thank you, Professor.
Thanks very much, Stephanie, and thank you also, Penilla. And hopefully everybody can hear me. If you can't hear me, do indicate that you can't hear me via your chat function. I'm delighted to be here. I'm joining you from Newcastle today. And I know that people from various parts of Australia have joined in, so welcome to this webinar. So the topic I'm really talking about is around technology and justice. However, there's also a piece in there around transparency. And part of my commentary around transparency also stems from some of the court and justice responses to COVID-19. Some of you may be aware that today, for the first time ever, the US Supreme Court began streaming live audio in relation to arguments that were taking place in the Supreme Court of the USA. This is quite exciting and really highlights to some extent about how technology has been available to open up the courts and enable greater access for many years. But that technology hasn't necessarily been used by courts. So some of my comments are around courts and technology, and some of them are around justice more generally. So I'm just hoping that my slide will turn over, and it seems to have frozen now, which is great. Oh, there we go. So when I normally talk about technology, I talk about basically three levels of change. Some of these are interwoven and are related to one another. However, it helps me better understand, if you like, some of the directions that we are heading in the justice sector to break it into these three levels. And the first level I normally talk about is supportive technology. And a lot of what we've been seeing across the justice sector and across courts and in terms of how lawyers work with their clients is really at this level of supportive technology. So a lot of that is the video conferencing that has of course taken off, whether it's through Microsoft Teams or through Zoom or through Skype or whatever it might be. And many of those supportive technologies have of course been around for some time, in some cases decades. However, their use in the justice sector has been somewhat limited. And of course, we're now seeing various forms of video technology being used across a number of courts. So there are other examples of supportive technology. So for example, if you've got really quite sophisticated websites which provide information for people, and most of these technologies are really around informing, supporting and advising people. Over the last 3 or 4 years, we've also seen an increase in the use of apps, which I'll talk about a bit more and even show you an example of an app and then query about how useful the app is in the justice sector. The second level of technology I usually talk about is what I would refer to as replacement technology. And replacement technology is technology that basically replaces functions that were previously carried out by humans. So a lot of the case management work within courts, a lot of the electronic filing systems, some of the online dispute resolution, and some of the apps that have been developed are really very much focused on these forms of replacement technology. And if you look at British Columbia, which really has probably the world's best known civil resolution tribunal, which is focused on different ways of filing, then you'll actually see how those replacement technologies will work. And I can see that there's a question up there about circulating the slides. Yes, I will circulate the slides in a PDF form. There's a video that I'll extract from one of them, which I can't unfortunately circulate, but I'll try and show it to you. In terms of disruptive technologies, often we're thinking about those technologies that can fundamentally change what happens in the system. So artificial intelligence can sometimes lead to the development of very disruptive technologies. And in that regard, I've written quite a few articles on, topics such as must a judge be human or judge be robot, which are really around the extent to which artificial intelligence may reshape, in particular, the lower levels of court decision making and what AI may mean in the context of justice delivery into the future. There's a lot of issues in this area, and I probably won't have a chance to go through all of the slides that I have on this topic. Suffice to say, though, that some of the issues are around the fact that algorithms may not actually reveal how decisions have been made. And there are some significant moves, of course, in Europe and elsewhere around the requirement where AI is being used that there be an explanation of how a decision was arrived at. But I will touch on that a bit later on. So my first comments are really around the first, if you like, area, the supportive technology area, and about why, in a sense, these technologies have become so interesting and what's driving some of these technologies. Some of it is because I think a large percentage of the population is online all of the time. And in the 11 years since we've had Apple phones and we've had better quality mobile phones where you can access the internet far more effectively, there's an increasing expectation amongst many in our population that they ought to be able to deal with a dispute online all the time and outside of usual court operating hours. We've also seen, if you like, an explosion in relation to what's called external dispute resolution and online dispute resolution. And that's partly been because so many consumer transactions are dealt with online. And when you've got a large number of consumer transactions online, you also need to have accompanying dispute resolution systems that can assist to resolve the disputes that arise out of those online transactions. And then I think in probably the last 5 years, we've also seen online dispute resolution being used in a wider range of disputes. So it's being used not just where people have had an online transaction, but in, for example, family law contexts, in relation to residential tenancy matters, and in relation to even some personal injury matters, particularly now in Canada. There have, however, been some really significant obstacles in terms of reform in these areas, and they are many and numerous. So some of them stem from the very low budgets that often exist within courts and the legacy technology systems that exist, which I'll touch on in a moment. Some of them are also linked to innovation, well, what I would call innovation readiness, and that's the extent to which those within the legal profession and judges are actually ready to adopt new technologies or consider that they might be useful. There are other concerns, and those concerns are linked to security and, of course, the confidentiality of data, which is translated in this digital world. And so I'll touch briefly on some of those as well. But when we actually look at what's been happening in the court-based area for some years, it's, as I said, about 11 years since we had iPhones. It's only really been about 22 years since courts have been using technology, in particular in a case management area, to actively manage what goes on. It's only 18 years since we've moved from those dial-up modems, and you can click on that link if you're a little nostalgic to remember what the sound of a dial-up modem was, and some of us remember what that was. It's been about 30 years since we had supportive technology, and often the supportive technologies initially in the justice space were, for example, where the Administrative Appeals Tribunal would send out a video of what a hearing looked like so that people would be better prepared when they came into an AAT hearing. For about the past 5 years, we've had some good textual analysis tools. Some of it's been very good and some of it has been less good. But a lot of that has led to, of course, the e-discovery changes, in particular in the US. For about 15 years, we've had artificial intelligence in the legal domain. And in fact, I was involved in 2 projects, one in 2003 and one in 2007, funded by the Australian Research Council, which really considered whether you could build artificial intelligence systems in the legal domain. In fact, you could, but they were fairly primitive systems that used what's called branching technology rather than technology that is constantly informing itself and, if you like, building a system, a decision-making system. So for the last 4 years, we've had these more sophisticated forms of AI. And in the last 5 years, we've seen this growth in what's called wearable tech, which is anticipated to continue for some time. At the outset, I want to say that one of the big issues that we have in the justice space is that often when we're trying to make decisions about what happens in terms of justice reform, we very much rely on the expertise of technologists. And I just really want to say that that's a very questionable approach. And I give the example of Yahoo. So Yahoo, of course, was a very large and major technology company at one point. In 1998, it made a decision not to acquire Google for $1 million. In 2002, it realised what its mistake was and then offered $3 billion, and with a counteroffer of $5 billion. And Google, of course, is now worth well in excess of $200 billion. In 2008, Microsoft made an offer to buy Yahoo, and Yahoo declined. And in 2016, they accepted a $4.48 billion purchase. And the reason why I've given you these figures is because clearly Yahoo wasn't able to predict the future. And also, as a technology company, it wasn't able to even track trends that it probably should have been aware of. And I say that because it really takes me to the point that to rely on the advice and views of technologists when considering what might take place in the justice sector is problematic. Not always. However, it seems to me that anything that a technologist might tell you, one has to consider very closely about how valid those sort of views about what the future might look like could be. So in terms of supportive technology and sort of coming back to it, I'll try and give some predictions where I can, based on what's already going on to some extent in the justice sector, but also based on what's going on in the broader society and in the context of technologies that are already operating. Some of the most significant changes, as I've already said, have been those in the supportive technology area, and those changes will continue for the next 5 to 10 years. So even apart from COVID-19, I think we can expect that there will be more supportive technologies introduced across the justice sector. And those supportive technologies will provide more information, enable people to lodge and claim, and it will be much more sophisticated than a lot of the technologies that currently exist. When I've looked at this on an international level to try and work out how different courts around the world are using supportive technology, some, because they need to work remotely now, have really said, well, you can file electronically, which is in some cases code for you can email us the documents, but they actually have no supportive technology that sits around that. We're likely to see significant advances in that area over the next 5 years, so that most courts will make it possible for you to lodge and claim. We're also likely to see changes in terms of court and tribunal processes, and some of those will be linked to developments in the UK and also in Canada, which involves a shift to managing disputes online. There's a piece of that where, from a lawyer perspective, there's an expectation that lawyers or chatbots or virtual assistants or something will be available for clients on a 24/7 basis and will be responsive to what clients might need. There's also this question about not being any need to travel, and we're already living in that era of sudden change in terms of COVID-19. Some of the issues around that are the extent to which things are kept open and transparent, which really brings me back to the first point I made about the US Supreme Court and its shift today. We're still not seeing a focus on transparency and open courts across Australia, though, and it will be interesting to see how that develops. I've got to say that in the context, and I'll just bring up a document that I've been working on over the last, this is a summary, if you like, of some of the changes that have happened across the world as a result of COVID-19. And I've tried to track how different courts are dealing with COVID-19. I've got to say that some courts have just completely closed down and are not available at all, and some have shifted to forms of video conferencing, often because they were technologically more agile in that regard. In many developing countries, though, courts have simply closed down because they are too concerned about the risk of infection. I sat in on a webinar the week before last at some dreadful hour early in the morning, like 1 a.m. And in there it was really quite interesting because there were judges from around the world talking about how they had responded to COVID-19. And in that webinar, at least a third of the judges, and there are about 450, I think, in attending the webinar, indicated that they had had people within their courts who had been infected with COVID-19. And it was partly for that reason that the court had actually closed down. But you can see that most of the developments are what I would frame as being supportive technologies or supportive developments. And really the only ones that have really focused on the more replacement technologies include the British Columbia Civil Resolution Tribunal, which of course has now been around for a number of years. In terms of the disruptive developments, most of those changes again are linked to what's been going on in China for some time, where you've got much more extensive and well-rounded e-litigation. As part of that, there's actually a series of AI schemes that operate, which are designed to nudge judges if, for example, there's a consideration that the decision that they've made is not in line with what is regarded as being the norm. And these are quite, I think, controversial issues in the context of European and other systems. Sorry about that, I meant to jump back to my slide. So supportive technology, yes, developing. Replacement technologies, we can also expect to see significant growth over the next 5 years. And a lot of that growth comes from that very large scale online dispute resolution environment. And Modria is probably one of the best known. And of course that was brought out by Tyler Technologies. Very interesting system, which was of course designed initially for the eBay and PayPal disputes and has dealt with estimated more than 1 billion disputes now, which is of course very significant. We're also likely to see a lot of systems that are based on chatbots that are better informed and seem almost human-like. There is a suggestion that at some point, if I have a complaint into the future, for example, my virtual assistant will be able to have a conversation with your bot and hopefully resolve the matter without me even being involved if I have a complaint. So these ODR systems are becoming quite sophisticated, and I'll show you a clip of one of them which uses AI now. oftentimes we're probably completely unaware that we're actually dealing with a chatbot or we're dealing with an AI system, and it may appear to us that we're dealing with a human. Oftentimes in the complaints sector, that's no longer the case. And then we've got the replacement technologies that are supporting the e-courts and the e-arbitration systems. And of course, a lot of work's been done in the UK on the redesign of Her Majesty's Online Court. So this will have impacts in Australia, and a number of courts and tribunals are currently working on not just digitising, but shifting to online systems. And then there are a whole series of boutique providers in this sphere, and I'm going to talk about one of them, Adieu, which I'm currently reviewing at the moment. And I wanted to make it very clear that my comments about Adieu are not intended to be endorsing that product, but I'm really showing it to you so that you're aware of what some of those products might look like. And then, of course, we've had a number of government initiatives where we've seen some lower tier administrative decision making, which has really been made by forms of AI. And some of that has been very problematic, and probably robo-debt is the best example of those very different forms of decision making that could be problematic. So in terms of this second level of change, you know, the replacement technologies, some of it is being driven by geographic issues in that, you know, when you have a large country and you have people on different time zones, it can be quite appropriate to have an online system which is managing the way in which claims are made and managing also to support people when they've got a legal problem. Some of the changes in this replacement area are around consumer preference. Some of it is about reducing cost and time, and that is still a significant issue across most of the court system. Some of it is because there is now more limited AI that enables more replacement technologies to be introduced. And of course, some of it is because many of these technologies are already well developed in the consumer area and are developing fairly rapidly in the administrative area. The question about the transplantation of the developments in those areas to the court system, though, is, I think, very interesting. So a lot of people will see the future of dispute resolution as linked to technologies like the Modria technology. And of course, what's significant there is that you're actually seeing a real reduction in the time taken to resolve disputes. We're likely to see a focus, I think, on this in the future, partly because of the economic fallout from the COVID-19 pandemic, when it will become even more important to try and resolve disputes quickly, particularly when people are economically stressed. So I'll show you one very quick example of an insurance company that's currently using a form of AI in claims assessment, which can give you a bit of an idea about what this might mean in the context of replacement technologies for the legal sector more generally. Again, I'm not endorsing this ad, which is available on YouTube. However, I am showing it to you to really make the point that this system has now been in operation for, I think, close to 2 years. And when you look at the ad, you can see fairly rapidly what might happen in a legal context. So I'll just put that on. It's quite a quick video, and then I'll continue.
Suncorp currently lodges over 500,000 claims a year. We do know from experience, obviously, customers would like to get their cars back quicker, so the sooner we can do that, the better. The customers can now go online and lodge their claim, determine the outcome, pay any applicable excess, and nominate a repair time and location they're choosing, all in that one seamless transaction, which is great.
The integration approach to implement Watson into the Suncorp process was to look at how the claim process works today, take a look at historical claims over the years, and see how they were assessed. Watson then essentially replicates that process by applying the same rules via a machine learning approach. Watson works by understanding information in the same way that a person does. Unlike traditional computers that are used to dealing with ones and zeros, Watson can understand things like the English language and all the nuances of it. So therefore can help with things like motor accident claims.
So we've built a decision-making engine which essentially determines liability through an algorithm and uses a lot of business rules to ensure that we're preventing errors or that we're preventing fraud. What Watson does is enable us to progress more claims online and gives our call centres some time back to focus on customer service and how we're dealing with those really complex claims and what we can do to make those experiences much easier for our customers.
So that's, I suppose, one example of the way in which fairly simple forms of AI are being used in the insurance arena. And of course, they're now being used across the board in a whole range of different complaint systems. And those complaint systems can be quite vast. So if you're thinking about banking complaints, or you're thinking about complaints in the telecommunications system, many of these are extensive. Now, there are some issues with these sorts of replacement technologies that I'll touch on a little bit later. Some of those issues are that the costs, if you like, of repair, and the Suncor example is a really good one, whether they're just fixed because the only data that is used or relied upon in the machine learning example is data that's already been there in the past. That is, there's no consideration given to increased costs. Now, a lot of the second level of change replacement technologies are founded on, if you like, large-scale platforms that have been developed as well. So in the consumer area, they've been, excuse me, very important in the context of European changes. So for many people, if they reside in Europe and you buy a product, then what you'll do is you'll end up on a platform which will divert you out to a form of online dispute resolution. And these are still developing, but you know, they've been in place now for more than 4 years, and so we're seeing significant growth in this kind of development of platforms. And I would really hope that we would also see that across the justice sector in Australia, but it will require, I think, some investment as well as an engaging way to consider how justice might look into the future. What we're also seeing is, I think I've got one question there, chat, so I'll just check. Are we any closer to the use of facial recognition software to assess the mood of complainants during use of AI systems? I've actually got a great series of slides on this, because I did some visual facial recognition tracking of myself and a colleague in December, where we actually tracked our moods, because the facial recognition software enables you to do that. And it's really quite interesting. If I've got time, I'll try and bring up those slides if I can locate them somewhere on my slide deck. But it's, yes, we are, I think, closer to the use of facial recognition software to assess mood. And I think that's really a fascinating area for the future, both for those working within the justice sector, but also for researchers. And I'm kind of quite interested about whether or not we can use facial recognition software and visual tracking to help assess what goes on in a range of processes. And that's Alan Shanks. Hi, Alan. How are you? I didn't see your name until then. So a very interesting area. But I'm going to show you another app, which is a bit more evolved and really is focused on engagement with people. And it's an app that I'm currently reviewing. So I'm going to talk about some statistics and perhaps some surprises that I've had in the review process in terms of who's actually used that app. And it's called the Adieu app. As I said before, I'm not advertising this app. It's been developed by a team who've been using it now for a couple of years up in Queensland. And the video itself is slightly out of date, but it will give you an idea about how these apps can work and how they might develop into the future as well. And as I said, look, it's a little cheesy and it is intended to be an ad, but I'm showing it anyway because I think it'll be interesting.
In every relationship, there are fine times and there are times when things get a little dark. And if your relationship breaks down, the separation cloud can hang over you for years. It gets complicated and you can't find your way. You're frozen by inaction. You don't know who to trust or what to do next. You want what's best for everyone, especially if you have kids. You're worried about assets, money, your future, and the separation cloud casts a shadow over everything. In the family law courts, if you start the separation process now, your case may not be heard until the 2020s. It's unsettled on the financial front too, with the average Australian separation wasting a third of everything you have. But there is a ray of hope. A bright idea that means your dark days can now be sunny. It's a new system called Adieu, and it's your path to positive separation. a simple, intelligent way to find your way forward with structured steps to a brighter future. Adieu brings 4 types of expert together with the power of artificial intelligence and the benefit of common sense. Lawyers, coaches, mediators, and accountants who guide you through the process. This low-pressure system puts you in control with unique technology that makes the process unbiased and actually more human. You know exactly where you stand, so you can see clear skies ahead, with a plan to resolve your situation in as little as 4 weeks. You invite your ex-partner into the process and work through it independently, or with the support of an impartial expert and lawyers. Property and parenting agreements are legally formalized with intuitive digital tools helping you reach agreements on what's fair and what's feasible without clouding your emotions. The best part is you can start to create your plan forward right now in just minutes. All you have to do is have a quick conversation with Lumi, the world's first family law robot. Start a simpler and more respectful conversation about divorce and separation now at adieu.ai.
So it's kind of quite an interesting system, and I actually had a fake divorce last year. It wasn't real, and I eventually told my husband I was doing it as part of my research work into this app. And you know, I thought, who would this app appeal to, and is it really just something for younger people who are going through divorce? And that was really what I wanted to talk about. At the moment, these are the figures that have come out. A fairly large number of people have already used the app and have generally been quite positive, although we're in the process of doing a large online survey to check on positivity. I think what's really interesting is that people from around the world have been interested in the app, but I'll just jump through relationship length. Sorry about that. I'll move through a bit more quickly. What I was really surprised about was the length of relationship in years in terms of people who have used the app. And what was interesting about that was that I would have expected that the vast majority of people were in the 5 to 10 year or shorter period. That wasn't really the case, in that there was actually a significant proportion who had had a relationship which extended beyond 15 years and in some circumstances beyond 25 years. And it really raised some questions for me around the use of replacement technologies and about digital divide and whether or not age was really a significant barrier. I'll just jump back in terms of how people were also accessing the app. Clearly people were doing it on mobile devices as well as on their desktop, and it really speaks to some of the developments that we're likely to see into the future, which is far more of these so-called justice apps really being available on mobile devices rather than on something else. So I'll jump forward just a bit in terms again of demographics. You know, some people had dependent children, but a large number didn't, particularly in that older population where the children had probably still somewhat dependent, but had were not considered to be dependent. So some of the trends that we're seeing in terms of technology around also the use of social media, which is problematic in itself, but the way in which courts are currently engaging in social media is quite limited. In the complaints area, it's again very interesting, because what we're seeing in the complaints area is a very large number of people who are now making complaints via social media, and I think an increasing expectation that they will be able to in some way access the justice system using social media. So this is quite interesting, I think, for the future. And of course, there are really significant issues and challenges in the context of confidentiality. And then the big second trend is the extent to which courts and tribunals wish to accept technology and the way in which it's being driven within courts and tribunals. In an article I put together with a colleague, Dr. Bin Lee, last year, we talked quite a lot about innovation readiness and our sense that clients were often innovation ready, lawyers were sometimes innovation ready, and courts and judges were also sometimes innovation ready. However, there were some significant issues around the extent to which technology was being accepted and adopted. So moving to the third level of change, and I won't spend that much time on it, these are really the disruptive technologies that can help us, can hinder us, and will very dramatically change what we do in the justice sector. And they're some distance away compared to the reforms, I think, at those first two levels. Again, there are some issues in terms of disconnection and increased hostility, but lots of potential benefits in terms of ease of access and ease of management. And then there's the job loss predictions as well. I think most people consider now that jobs will be altered often rather than lost. And this is quite interesting in the context of the legal profession, with futurists, I think, suggesting quite different impacts. Many futurists now suggest that, in fact, lawyers are relatively safe, although their functions will change as a result of disruptive technologies, and that disruptive technologies will in fact enable more access to lawyers who are human. The piece around job loss, though, is very interesting when one considers administrative decision makers, lower tier judges, who may be more at risk in terms of replacement in the context of AI. And then there are other significant threats to privacy. And of course, these really haven't been grappled with sufficiently. And in the context of COVID-19, also causing concerns. I'd say in relation to threats to privacy, that realistically nothing that takes place online is in fact assured of being private or confidential, and so there are significant issues there. And then there are the loss of interaction issues as well, and I think that those are very interesting in terms of community cohesion and what happens when you have more disruptive technologies that mean that our engagements and our communication are conducted online, and even some of the basic decision making is made for us by algorithms. So, I mean, these are some examples of different disruptive technologies that will, to some extent, result in a growth in litigation, and they will also change the way in which we do business, everything from wearable tech to robots conducting funerals. I mean, the list goes on. And these will change very much about how our society works, and our justice system is, to a limited extent, a reflection of societal changes. So in terms of what a judge or arbitrator will look like, to what extent, as I said, the lower tier of decision making will be replaced by AI is, I think, really interesting. It seems to me that there is some inevitability there in at least some courts. Now, courts vary across the world and significantly differ in terms of the judicial role. So in some places, for example, in China, there is a lack of clarity around the separation between the judiciary and the executive. And in those types of environments, there seems to be a greater acceptance that you may have AI, which has an impact on judicial decision making. And in fact, you may have a greater acceptance of AI replacing some judges, particularly at those lower tier levels. In other jurisdictions, such as Australia, where the evolution of precedent is so important, there are other issues that are there. Now, I've just got something coming up on a Q&A. What about literacy levels with some of these apps? I know many legal aid clients need significant help preparing the basic statements and working out how to articulate what they want. That's a very good question, and it is a digital divide question. And just sort of taking you back to the Adieu system, I've actually talked with the Lumi robot, and it's really interesting because it can have either a male or a female voice when you talk with that robot, and what it does is ask you a whole series of questions that you respond to. Can you tell me a bit about yourself? Do you have any children? Where do you live? And while you're responding to it, it's actually populating some documents in the background that can be used later in terms of consent orders. So there is actually scope, I think, for some of these apps and more developed systems, more developed AI systems, even to assist, I think, some of our most vulnerable people within our community. There is, however, no doubt at all that some of the most vulnerable within the community simply can't access these systems because they're not connected, or if they are connected, they have difficulty, I think, understanding and translating what's going on. So in that regard, yes, there will be, I think, a continuing role for humans. However, I think we can expect the AI to improve and hopefully address some of the issues that arise with our most vulnerable populations. I am surprised, though, in this context, often when I've written about the digital divide, I've talked about the over 65 and under 65, if you like, divide, and that for many of the elderly, they have particular issues with technology. However, I think COVID-19 has shown us that many people can change the way in which they operate and can use remote technologies as effectively as younger people can. Not everybody, but that's certainly something that is there. I'll just go back to the slides and talk about maybe some of the issues. Many of you would have heard about the compass issues and about algorithmic bias. And this is really this issue around where algorithms are already involved and engaged in decision-making at the moment. And yet there's actually no clarity around what those algorithms do. And probably the best one was discussed in the context of the Loomis case in the US. There is, however, despite these critiques, a growing acceptance that you will have these algorithms being used from everything from policing to making parole and also sentencing decisions in some jurisdictions. Less so perhaps in Australia, but it's certainly a relevant factor in many jurisdictions. Now, I've given you this slide, which looks terribly confusing because it's one that we put together, John Zalesnikoff and I, when we were looking at how do you determine sort of a basic expert AI system that legal aid could use to determine whether or not legal aid should be granted under different circumstances. And what it did was really basically determine whether or not somebody was likely to be found guilty as a result of a court hearing process. Quite a simple system, and it uses what's called branching technology. And at that point, what you did was you went out and you interviewed a range of experts about things that they thought were relevant in terms of the decision making, and then you inserted it into a simple AI system. The much more complex AI systems that have been developed now are quite different, because what actually happens is the form of AI learns on a constant basis. And so there are issues there around what data is given to the AI or provided to the AI to enable that learning to take place. And those are issues that are being grappled with in a range of different contexts. But what we can expect is that there is a much broader, if you like, understanding about the data that's required. Clearly, you can't just look at court system data or judgments, because if you did that, you'd really only be looking at probably the most aberrant cases, because they're the ones that end up often before a judge. So the sorts of data that's required to inform AI development in the justice sector is quite broad. And those are issues that we need to face into the future, particularly as many of our courts don't currently have electronic filing or electronic filing that can be, if you like, interrogated by a form of AI. But nevertheless, the changes that are happening quite quickly, and over the next decade we'll begin to see more sophisticated AI in the justice sector. And just to explain the differences, so that everybody is clear, it's really this machine learning and deep learning component, if you like, of AI that's going to become much more relevant in the legal sector. So what's the role of judges? Will judges be phased out? Probably not, because the work that they do is actually quite complex, and it's not just decision making. However, there will be, I think, significant shifts in the judicial role, probably not within the next 10 years, although they will have started by then, but over the following 10 years, yes, definitely as a result of AI changes. And then there are these issues that we have around the legality of a decision made by an AI judge, whether we can translate law into code, you know, how the judicial system promotes evolution. I suppose one of the concerns that I've got is that you may have decisions or draft template decisions made by a form of AI, but to what extent will they actually be reviewed by humans? And to what extent will humans depart from what is an AI recommendation if it's being used in that way? So some quite significant issues also around legal authority and these questions around how community values are then translated into a revised justice system. Everybody's being very quiet at the moment, so I'll just try and wrap up fairly soon so I can take some questions. I suppose the reality is that already in the US and certainly in Australia, there is quite a lot of judicial commentary about AI and also about technology and judges. And I think some of the judicial leaders within our society are recognising that there will be considerable strains placed upon courts and others to understand the ramifications and to some extent to introduce sound ethical decision-making processes that assist courts and judges and policymakers to consider where and how AI can be used. On the whole, though, much of the work over the next 5 to 10 years will really be around supporting judges rather than necessarily replacing them. However, there are some issues there around, as I said, the extent to which humans actually end up reviewing many AI decisions. And then, of course, there's these other questions about whether you can augment a judicial officer or transhumanism in terms of improving our bodies so that we make better decisions and, what that might mean into the future as well. I note that Susskind in his talk the other day talked a bit about changing the jury system so that you didn't just have 4 juries, but 4 jurors or 12 jurors, but in fact you could have almost a democratic pool of jurors. I think some futurists consider that that is possible and note that by 2050, the predictions were that we would be able to download our brains effectively into a computer system. And so that might mean that some forms of AI are in fact informed by humans at some point, but that's probably taking me a little bit to a Black Mirror approach in terms of all of this. This was the comments that I noted before just about the developments in Chinese courts, which I think are interesting. There have long been issues and concerns around judicial bias, and the Chinese courts are attempting to use a range of AI techniques to try and move beyond issues of bias. These do, however, sort of really raise some significant issues around the way in which the executive is involved in judicial decision making, and also raise some very important issues around the retention of independence of judges. So the main issues for the future are really around the way that we make ethical decision making in this field into the future, and we're informed, I think, fortunately, by ethics outside of the justice space. But more importantly, in Europe, there's been some really interesting work on the use of AI in the judicial systems and their environment, which hopefully can guide us a little bit into the future. Now, I'm seeing I'm getting some questions coming up, so I'll just jump to those chats. AI can double down biases, absolutely. Lee, AI can actually make the biases and the problems even worse. So I would have to agree with that. You'll actually see that in the context of the European Commission, they have considered that, and also this idea around dignity, which I think is very important, but also transparency and impartiality. Whoever, if you like, considers the data and considers the AI linkages may also be biased, and I think that has to be said. So, Judge AI, we probably need to develop a well-being and a human dignity threshold ethical test, and we also need to make sure that we've articulated human rights in the context of these changes in the justice system. I think most importantly, though, is really focusing on a human-centred legal design approach that must include the judiciary and others, rather than having amendments and changes that take place without input from ordinary citizens, as well as judiciary and the legal profession. So I'll jump forward because it's just about time to wrap up. This slide, just in case you get that in the slide pack and you're interested, suggests that you can see lawyers on the far side of the screen, suggests that lawyers are less likely to be automated than judges who are somewhere in the middle of the screen. And I'll just jump forward. I told you I had too many slides. So any questions? I'll throw it open for any questions. And thank you all for listening so patiently.
Tania, I was just wondering, given the use of AI currently, whether you see there's any underutilisation of AI in current areas of Australia's legal system now that could be implemented relatively quickly?
I'm not sure about relatively quickly, but there are, and in fact, I'm just finishing a short book on the use of apps in the justice sector. There's some really interesting developments in terms of the use of apps, which are kind of often sophisticated chatbots that use some basic forms of AI. There's definitely scope for more use of these different approaches. We know, for example, from international justice research studies as well as local research studies, that there is a significant amount of unmet legal need within the community, and that many people, when they have a legal problem, can't access a lawyer and are concerned about that problem, and it can have, devastating impacts for many people. Some of what these bots do, and Adieu's an example, I suppose, of an app that does it as well, is what they effectively do is help triage a dispute so that people can get advice. So the way that Adieu works is that in my pretend divorce that I had last year, Adieu referred me to different people based on the sorts of material that I had disclosed to Adieu in terms of conversations. And that, I think, is a very useful function. We currently don't have those triage techniques that are well developed for our most vulnerable people in the community, but also just for most people, I think, in communities. They also take us to a place where I think legal unbundling will become, again, a hallmark in the future, where it may be that an app with some basic AI refers certain aspects of a dispute to you, and then we of course need to clarify what the arrangements are for legal unbundling into the future. But all of this could actually result in more work in some senses for lawyers rather than less, because a lot of people who may never have previously accessed a lawyer or talked to a lawyer may now have platforms that enable them to do that and in fact support that kind of access.
I was thinking that, and also whether on the flip side of things, whether the AI result would have proved perhaps insufficient for some people, and then they would need to go the further step to another resource, which was, an appeal process to a person, but it seems like from the statistics that you were putting up from Adieu that actually the success rate is very high.
Yeah, I think it is, and it really. But there is access to human beings as part of that that approach, and so the human beings aren't left out of it. The way in which people access those human beings, though, is different, and the sorts of reminders and things that you got through that process are quite positive and quite supportive. So it's interesting around how this will develop. But I would really like to see, some really broad justice platforms in place that assist people, so that they're not just relying on Google searches that are often inaccurate and quite unhelpful. In the same way that Dr. Google might not be all that helpful, Google SC is often also not helpful for people. So it's a much more sophisticated way of, I think, getting some information about what the next steps could be, and in some cases also supporting you on the way through. I mean, the British Columbia project is a really interesting one, because when you lodge a claim there, you're actually taken through steps that help you craft a letter that you can send to the other side, and there are ways of supporting people to negotiate directly. And then if that doesn't work, then there are ways in which you can access different sorts of expert advice after that point, often with humans involved, or most often with humans involved. Yeah.
And with your research projects, have you seen any particular ethical issues arise?
Well, I think the confidentiality and privacy issues are really extensive, and as one of my other roles, I'm still the industry dispute resolution advisor for NBN. So I have a sense about some of those confidentiality and transparency issues across all technology platforms, and they are really extensive issues. However, the uptake in Zoom as a result of COVID-19 suggests that many people are likely to waive some of these confidentiality and privacy concerns on the basis that it might be a more convenient system for them to use. So there's a juggling piece there around convenience and around, I think, privacy and confidentiality. So interesting to see where that lands. Even with security upgrades, there are still issues, I think, that exist with all technologies.
Yes, definitely. Well, we're nearly at our time. Unless there are any more questions, I might wrap up and say thank you very much. It was a really interesting presentation, and great to have you back again. So thank you very much for your time, and thank you everybody for joining in on this event.
Great, lovely to see you all, and thanks everybody.
Thank you.
Oh, hang on, there's one. Oh, just thank you. Oh, how sweet. Thanks everybody. Bye everyone.
See you later. Thank you.